Hello and welcome to the program. The International Tribunal for the Law of the Sea, which on May 10th considered the case of Ukrainian sailors captured by Russian forces near the Kerch Strait, will deliver its ruling on May 25th. Ukraine has said its ships were located in international waters when the incident took place. Now, Russia, however, refused to participate in the court hearing and claimed that the Ukrainian ships entered Russian territorial waters without permission. To discuss this, we're joined in the studio today by Tsymbrivsky. He's the head of USAID Human Rights in Action program. Hello, and thank you for joining us.
Thank you for having me. Hello.
So, first, a bit of a reminder for our audience. On November 25th, 2018, Russia captured 3 Ukrainian vessels in the neutral waters of the Azov Sea. As a result, 24 Ukrainian sailors were taken prisoners by Russian forces. Now, Ukraine asked the International Tribunal for the Law of the Sea to impose temporary measures with respect to Russia to release Ukrainian naval sailors. Now, what was the value of this court hearing?
Actually, this is a part of the ongoing litigation which has been undertaken by Ukraine in terms of overcoming the consequences of the armed conflict between Russian Federation and Ukraine. And of course, it is a very logical step in that direction and should be welcomed, especially in terms of the Tribunal of the Law of the Sea, since as Ukraine and as Russian Federation, they are both parties to the United Nations Conventions on the Law of the Sea, which was signed in 1982. And that means that some of the disputes are subject to the Tribunal, which is composed under this convention, and Ukraine lodged its complaint. And on the 10th and 11th of May, there were preliminary hearings. As you have mentioned, Russian Federation did not show up at these hearings. Nevertheless, it handed in its memorandum, dwelling on its basic legal claims and clarifying its position before the tribunal. And it doesn't mean that, given that the tribunal should exert its jurisdiction over the case, which should be the first issue to be addressed by the court, it wouldn't preclude this court from its ruling henceforward. And we have some experience to look at. For example, the case which was engaged Russian Federation Arctic Sunrise between the Netherlands and the Russian Federation. The Russian Federation did not show up at these hearings. It made specific reference and reservation concerning that this tribunal does not have any authority and no authority to deliver any rulings, but nevertheless it ended up in the ruling on the side of the Netherlands, despite that Russian Federation did not appear in the court. But it was rather specific situation, since legally it did not comply with its decision, since it was more bound and more relied on some domestic decisions which were based on amnesty, releasing the crew and the ship itself. But it was sort of like a mixed approach taken here, and I would dare to assume that something similar would happen in the case with Ukraine.
But Russia wasn't in conflict with the Netherlands at this moment. The specificity of this Azov Sea situation is it that Russia is in conflict with
I totally agree with you. It was just the sort of example to look at. It's not completely relevant due to the fact that we are in the international armed conflict as it was established by the preliminary findings of the International Criminal Court so far. And the investigation is due to be open, and this is a very significant fact which should be taken into account. But my reservation towards this case, which is very strongly composed in my view and in opinion of some esteemed experts as well, that it is purely based on the friendly relations. It disregards the context of the armed conflict, and perhaps this is done intentionally, since the tribunal is not the proper tribunal to look into these issues. but nevertheless, I wasn't sure that this would never happen given the armed conflict didn't take place before. But still, I am more than confident that this tribunal will most probably deliver the decision which would be favorable to Ukraine's position, and in the end it will result in the release of the 24 Ukrainian sailors and 3 warships which had been illegally captured by the Russian Federation.
Now that's this decision could be I mean, on the matter of the law, quite interesting if it's favorable for Ukraine, because it would mean that the Azov Sea is recognized as waters, like neutral waters, what basically that Russia doesn't admit since it illegally annexed Crimea, and also that Ukrainian sailors would be then prisoners of war. So would it be the beginning of, let's say, a recognition, even inadvertently, from Russia that it is part of the conflict?
I would like to emphasize that in this very case, it is built essentially on the immunity of Ukrainian warships, and this is the key position which has been taken by Ukrainian agents before the court. This means that under the convention, which was already mentioned, that warships, they enjoy immunity, which is absolute one, regardless their position in the territorial waters or neutral waters or elsewhere. And that means that the other ships could not exert any authority since they are sovereign. We could make another example that such a sovereignty exists in terms of embassies or consular staff, which also enjoys such a sovereignty. And even given when such ships, they go into territorial waters, let's assume this is not the case here, and this means that the coastal state could only ask these ships to flee out of these waters.
And not to attack them, and not to seize them.
And not to attack. But conversely, the actions which were taken by the Russian Federation could be justified in terms of the international armed conflict. This is a purely justified action, I would say, since we are talking about belligerent parties, Ukraine and Russian Federation. They are in the waters in the Kerch Strait, which is the water domain, which is the continuation of the land domain and air domain, which is under occupation by Russian Federation, and this means that this is theater of war, and that's why the rules should be relevant and applicable international humanitarian law, which are more relevant here rather than the convention invoked by Ukraine, as I previously mentioned, but still it would Ukraine could leverage by virtue of this convention for the release of the sailors, but in the long run, I'm sort of pessimistic, since for the broader litigation cases which are brought about in order to counter Russia's aggressions, this case would be sort of erased, I would say, since it disregards the context of the armed conflict. It doesn't take into account also the issue of the prisoners of war. Of course, not due to the fact that the United Nations Convention on the Law of the Sea doesn't cover such issues.
So you're saying that even though Ukraine wins, let's say, this case, and the decision is, let's say, favorable to Ukraine, it cannot be added up to the whole pile that Ukraine filed since Crimea's illegal annexation, since Ukraine is proving and trying to prove that Russia is occupying Donbass and all that things.
Actually, this is my own perception of the situation. For example, we couldn't use this very case in terms of future litigations, which would be ongoing, for example, in the International Criminal Court or elsewhere, since it will mean that there is no armed conflict, actually, yes, in terms of this very case, since we are talking about United Nations Convention of the Law of the Sea, which is applied only during the friendly relations, not in terms of ongoing armed conflict, which is actually taking place, regardless of the position of the parties which are engaged in this conflict. Conversely, as we look into the domestic domain, it is quite opposite position, since in the courts of the Russian Federation, all the sailors, they deem themselves as prisoners of war. So we see like two different approaches. The latter one is a bit more reasonable in terms of combating the aggression of the Russian Federation, but these are different legal regimes. We should take it into account.
Now, we talked about a little bit about the technicalities and the law technicalities here, and now I just want to focus a little bit on the situation of the Ukrainian sailors. Does the fact that being put under the, let's say, the umbrella of the Geneva Convention, does it ease their conditions in Russian jails, being prisoners of war, or does it complicate their conditions and therefore their release?
It is a proper stance taken in the litigation in Russian courts, of course, since it is prescribed by the Geneva Conventions. And all of the sailors, they made the declarations, and this is like the strategic approach taken here in order to litigate this case. And of course a lot of rights and privileges should be granted to these people. Alas, this is not the case, since the Russian Federation would otherwise say that this is like an armed conflict, and Russian Federation is not interested in it. So it is a very tricky situation in both sides, in international arena, I would say, and also in the domestic domain. And most probably the ending up of the story also would be a mixed one, like a mixture of legal and political instruments, alas, although I would welcome more legal instruments to be invoked, since it is more proper instrument to tackle such situation. And I am more than sure that International Tribunal will deliver the decision in favor of Ukraine, since we are witnessing a lot of tensions elsewhere, not only in the Sea of Azov, Kerch Strait, let's see at the South China Sea, or elsewhere, where we see different harassment of shipment.
With the Chinese fleet basically
being... So this is a very important issue and sensitive one for all international community, I would say. So
would it... you raise an interesting topic here. If this score, once again, is favorable to Ukraine, would it create a precedent that could be used, as you say, in the Chinese in the Sea of China, southern China, basically that some little countries could sue China over its aggressive behavior in the Southern Sea?
I guess yes, it would be a very strong message to other countries elsewhere in order to invoke such a case against other countries which are harassing shipment or otherwise intimidate free shipping. And I don't know what would be the further development, since it is a rather big issue also of the implementation of the decision which would be granted by the tribunal. So it is a very long process, of course, but we should invoke such dispute resolution measures in order to be committed to international obligations and to show international communities that this is a proper way.
Which brings me to my next question, whether it should be a case of these small countries against China or Ukraine against Russia. How to make this decision implemented on a realistic level? How to make Russia understand and, let's say, apply those decisions? Because Russia is known for not respecting international conventions and international right and law.
Very correctly, as you have observed. Actually, the recent order which has been delivered by the ICJ in the case between Ukraine and Russian Federation has not been fulfilled by the Russian Federation, alas. And we also see some other instances, rather wide array of such things, but nevertheless we should pursue justice in international domain in order to show the credibility and the capacity of the international institutions, which are malfunctioning, of course, due to many restrictions they have, but still there is no other way to look at. And a lot of challenges ahead of us, and this is not just the case of the Russian Federation. It could be either China, either USA, either a smaller country. It doesn't matter, but we see indeed very pressing issues also in the Arctic, where Russian Federation is trying to tide up their pressure. In terms of implementation of such issues, I guess that some political pressure would be welcome too. Sanctions policy in order to tighten grip on Russian Federation, and also perhaps communication with societies abroad, society via society, I guess. It is also very important to conduct such a dialogue. So any instruments could be valuable.
So it's a whole package of basic means and to pressure this country that you're
I guess yes, since there is no solution to this very complicated problem, but we should seek it.
Now, and to conclude this interview, you talked about, this is about the Azov Sea, we talked about the Sea of China, we talked about the Arctic. Do you see the maritime environment and the sea in general as a new form, a future form of conflicts here, evolving in between those countries?
I would assume it has always been such a domain for the conflict between the countries, especially starting from the 16th century when the coastal states began to exert their authority over the waters. Now it's more topical issues, informational warfare, I would say, and also some other such crafty instruments which are applied and utilized by many countries, such as lawfare, a very brand new approach which is utilized not only by the Russian Federation but other countries. For example, they are justifying illegal actions invoking provisions of legal obligations. Namely, it could refer, for example, when the annexation of Crimea is called the manifestation of self-determination, which is
twisting law to basically serve a certain
which
purpose.
is deeply rooted in international law, or issuing passports in Donbass for the sake of humanitarian needs, so-called. So this is a brand new lawfare, but we should be very sensible to this question and look very closely to its manifestation.
Well, thank you very much for this overview. It was a pleasure to have you in the studio to shed lights on these issues. That was Taras Tsymbrivsky, head of USAID Human Rights in Action program. Thank you for watching the program, and stay tuned for the rest.